I'm going to wait a couple minutes.
Oh, you are? Okay.
No, you stay there, please. Just a couple minutes. What we're trying to do is figure out how we end up tonight and get everything done we got to get done. I think we got a plan here.
You got a plan?
Wait.
Thank you.
Oh, yeah.
15.
We're going to give 30 seconds to Senator Franklin, but not right now, and then go, then go to Coons. And after we finish the second round, we will do what's been done for the last 30 or 40 years with a nominee. We're going to have a closed session, and then we'll reconvene after we have the closed session. And then we'll start our third round. In other words, at the end of the second round, I should make clear we're going to have this closed session. and by doing that, then when people are done with their third round, if they want to leave and not come back, they won't have to. And then for the third round, I think I've consulted with a leader here that we would allow 15 minutes, but we would hope that you could do it in less than 15 minutes so that we can get done sooner than we got done last night. So that's the way we'll handle it. And I hope not everybody wants a third round, but I can understand if everybody does want a third round. This is a very important part of our function as senators, so we'll do whatever it takes to satisfy everybody so the questions gets asked that you want to ask. Senator Franken for 31 minutes, 31 seconds.
Thank you. Thank you, Mr. Chairman. Judge Gorsuch, you were right. The Federal Arbitration Act was passed in 1925, as you said, not 1924. As I said, I was wrong, and especially so because I chose to correct you when I was the one who was wrong, and I humbly apologize.
Not at all. Not at all.
That doesn't happen very often around the Senate.
Enjoy it.
Senator Coons.
Thank you, Mr. Chairman, and thank you, Senator Franken, and thank you, Judge.
I say right.
I'll submit for the record, as many of my colleagues have, two more documents, an editorial from the Washington Post from Matt Witt, who experienced the hardship of depriving individuals of the ability to make their own end-of-life choices when his mother endured a painful death by refusing nutrition, and a letter from 21 national LGBT groups expressing concerns about Judge Gorsuch's opinions and whether they do indeed respect fundamental rights that would enable them to be protected from discrimination.
Without objection, those are entered.
Thank you, Mr. Chairman. Judge, I enjoyed our conversation yesterday about Hobby Lobby and your writings on assisted suicide, and I want to return to our discussion of privacy and the autonomy of adults to make their own decisions, even when it might conflict with settled law or with the majority's view of morality. And yesterday, when I asked you whether the Constitution contains a right to privacy, you agreed that it does. And I was glad to hear that, but you went on to describe this right and its origins. And you cited, I think, the Third and Fourth Amendments and two cases from the 1920s that have to do with parenting, I think Pierce and Meyer. But you didn't mention more recent cases where the right to privacy has been central. Griswold protecting access to contraception, Roe and Casey protecting a right to choose an abortion, Lawrence and Obergefell, protecting a same-sex couple's right to intimacy or to marry. And I think it's important to establish that when you agreed there is a right to privacy in our Constitution, that we were talking about the same thing. In general, this area of substantive due process and right to privacy is one about which there's been vigorous debate. So I thought it was constructive for us to have a broader conversation about it. First, do you agree those cases that I just cited all relied on the right to privacy as an essential part of their holding?
Senator, you and I were discussing, I believe, some of those more recent cases in the line of 14th Amendment substantive due process
Correct.
case law. And all I was pointing out, or trying to at any rate, was that they have a provenance that goes back quite a ways.
That's right. So would you agree that these are cases, the ones I just referenced, where the right to privacy really is an essential part of their holdings?
I agree they all grow out of the 14th Amendment due process liberty component, which has been interpreted by the Supreme Court to include privacy in a lot of different areas.
So would you agree, just to make sure I've understood you right, that the right to privacy today extends to protecting women's right to have autonomy over their reproductive choices and protecting the privacy of intimate relationships between consenting adults, whether same-sex or opposite-sex?
You have Casey, you have Lawrence, you have Obergefell. All of those are, I think, in the line of cases you're talking about, Senator. Yes.
And so let's take a minute and look at Casey and how it explores and identifies this right to privacy. It's now, I think, 25 years old. It's a 92 case. It reaffirmed the constitutional right to choose an abortion. And the opinion of the court notes, and I'm going to quote here at some length, that these protections extend to matters involving, quote, the most intimate and personal choices someone may make in a lifetime, choices central to dignity and autonomy, central to the liberty protected by the 14th Amendment. And at the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, of the mystery of human life. Beliefs about these matters could not define the attributes of personhood were they formed under compulsion of the state. I think that's a well-known, quote, piece of the Casey opinion. Is that familiar to you?
Generally, yes.
And in your book on assisted suicide, you say, and I quote, that it remains unclear whether Casey's mystery of life passage is properly understood as a persuasive but non-binding dictum. By calling this central section of the Casey opinion dicta, are you saying that future courts don't need to pay attention to it?
No, Senator, and I wasn't even, I don't recall being that emphatic about it.
Okay.
What I said was that obviously Casey reaffirmed the right to abortion, generally, in Roe. And then the question is, what additional work does that language do?
Right.
And that remains an open question in a lot of ways, what additional work that language does.
Well, then let's explore that if we could. Should this Casey language be relied upon in other cases?
I think that is going to be an argument that counsel will make to a court, and the court will have to consider through the proper judicial process: briefing, argument, decision.
Well, let me just argue that it has been relied upon, that it was essential to the holdings in Lawrence and Obergefell. If that's correct, and it's been relied upon in subsequent key Supreme Court cases, is Casey and this particular piece of the Casey holding indisputably settled law?
Well, Senator, Casey is settled law in the sense that it's a decision of the United States Supreme Court, right? And you also have Obergefell and Lawrence. Those are all precedents of the United States Supreme Court entitled to the weight precedent, which is quite considerable, as we've discussed.
Well, and we've talked about precedent. You've talked at some length about what are the tests of precedent. And one of my concerns here is that the language in your book, I would argue, lays out a roadmap for ignoring this section of this holding or minimizing or marginalizing it. Do I misread your writings here?
I don't know what you're referring to exactly, Senator. I'm sorry.
The section in your book on assisted suicide where you say Casey's mystery of life passage is persuasive but non-binding.
Again, Senator, I'm not sure that's an accurate portrayal of the book in the first instance. I think I said that an argument could be made to that effect, at most, because you had two holdings in Casey, right? You had one, a stare decisis or precedent-based holding.
Right.
Roe's upheld because it's precedent.
Right.
God bless you. And second, there was a second argument for upholding Roe, and this is part of it, this language. And so both are sufficient to the day, right? And sometimes, as a court, you ask which is the binding holding. Sometimes there's a whole law of, actually, not just the law of judicial precedent,
Right.
but a law of interpreting when we have multiple holdings.
That's right.
Right, Mark's opinion, for example, okay, which talks about how you pick which holding is binding in the future. So, Senator, we have a whole law that applies here.
I understand that.
And a whole body of case law.
And it's
I'm-
exactly because of that, and what I think are concerns that you raise about whether this is precedent that should be relied on, or a section of the Casey opinion that should be relied on, that I just wanted to emphasize, I view it as an important foundation, this mystery of life passage and the substantive due process views that it expresses, really central to Lawrence and Obergefell. They are rooted in Casey's interpretation of liberty under the 14th Amendment. So would you disagree with me that Lawrence and Obergefell squarely rely upon Casey's view of liberty under the 14th Amendment?
Senator, I think it would be an injustice to Lawrence or Obergefell for me to sit here and try and characterize them in miniature. They are thoughtful, lengthy opinions that have a considerable amount of analysis under themselves. And I would just say they are what they are, and they're precedents of the United States Supreme Court. And
So
deserve,
they are precedents, and you would view them as binding and as settled law?
Senator, they are precedents of the United States Supreme Court, do all the weight of precedent of the United States Supreme Court. And I've written a book about how much weight that is, with 12 judges from around the country, appointed by presidents of both parties. And Justice Breyer was kind enough to write a foreword. And it presents the mainstream view, the consensus view. Think about that, 12 circuit judges agreeing on 800 pages.
If you could get 50 senators to agree on something, you'd truly be worthy of
I'd be happy if I could get 20 of you to agree.
That's correct. So let me continue with that exploration if I could. So if these cases, Lawrence and Obergefell, are settled law, and they are relying critically on this understanding of substantive due process that is rooted in Casey and its analysis, under what basis or circumstances would they be subject to reconsideration? When might they be open to being reexamined if they're currently indisputably settled law?
Senator, every precedent is subject to a presumption that it stays, right? Francis Bacon called precedent the anchor of the law. Alexander Hamilton said that judges, because we're life tenured,
Right.
need to be bound down by strict rules and precedents.
Right. And I think in your opening exchange with Senator Grassley, you identified just a few factors. A
I'm happy.
reliance interest,
Yes.
whether it's been reaffirmed repeatedly, whether the legal construct it was on has been upheld, or whether it's an island unto itself. Is that, am I roughly remembering your?
There are a number of factors,
Okay.
and you've named a few of them, and they're all outlined in the book, among other places, and the Supreme Court precedents.
Well, let's move to a key moment in this line of cases where settled precedent was overturned. You testified yesterday that Justice White was your judicial hero, a justice for whom you clerked. And with all due respect, I think Justice White, who was an exceptional football player and jurist and Coloradoan, but in this particular line of cases, I think he was on the wrong side in Casey and in Bowers. So let's discuss Bowers v. Hartwick, which was a case that upheld a Texas statute criminalizing sexual intimacy between same-sex couples. In his 1986 decision in Bowers, Justice White declined to extend due process protections and recognize any fundamental right of intimacy. And in 2003, the Supreme Court directly overturned Bowers and Lawrence. Justice Kennedy wrote the Lawrence decision in reliance upon this Casey language, and he didn't mince words. Justice Kennedy said, and I quote, "Bowers was not correct when it was decided, as it is not correct today. It ought not remain binding precedent. Bowers should be and now is overruled." You clerked for both justices, White and Kennedy. Was Justice Kennedy correct in stating that Bowers was wrong when it was decided?
Senator, that's the law of the Supreme Court. And you're right, I clerked for both men. I admire both men greatly. Both taught me an awful lot. And I'm not here, and I will not say a bad word about either one of those gentlemen.
Well, I wrestle with your admiration for Justice White when his jurisprudence fails to recognize what I and the current Supreme Court and many Americans view as a core liberty interest inherent on each one of us. Obviously, justices can be revered for their writing and their decisions, even when developments in the law and history have long passed them by. You've also expressed admiration for Justice Scalia, and he dissented sharply, memorably, in both of these same-sex decisions. He actually said in one of those dissents memorably that the majority's holding would mean, and I quote, that state laws against bigamy, same-sex marriage, adult incest, prostitution, adultery, fornication, bestiality, and obscenity would be called into question. As a legal matter, do you agree with Justice Scalia's statement in that dissent?
Senator, that's a dissent. It's not the controlling law
That's right.
of the Supreme Court.
And sometimes
And
dissents
Senator-
are meant to signal a direction a certain justice would like the law to go.
I'm sure it does, but it's a dissent. And Senator, with respect to Justice White, I'm not here to spend undue amount of time defending him. But we all, everyone, I know you've indicated you disagree with him. That's fine. Every one of us makes mistakes at some point in time.
Did he
And
make
I
a
don't
mistake
think-
in Bowers?
Senator, the Supreme Court has held that. Justice Kennedy held that. As you pointed out, you read the language. That's the binding law of the Supreme Court of the United States. And Senator, I revere both men greatly.
But if you would, Judge, what I'm looking for is some sense of your understanding of the scope of this substantive due process analysis in Casey, because you took the initiative to write that it should be understood very narrowly, that it might not be something that would stand the test of time, because a justice you identified as your judicial hero didn't agree with it, and a justice you did not describe as your judicial hero overturned it. So I'm
Senator,
just
I'm sorry to
expressing
interrupt
concern.
you, but that's not correct.
Okay.
If you took away from my discussion that I don't consider Justice Kennedy a judicial hero, then I'm sorry, because I thought I made that very clear in my opening remarks before this body. And if I didn't, I want to make it real clear right now, all right, that I am
Duly noted,
immensely grateful. Senator, I can't let that pass. I'm sorry.
You did note in
Justice-
your opening
Justice-
that you learned
Justice-
from him respect for
No.
litigants and that you admired your time with him. And I remember you saying very positive things about your clerkship
I'm
with
glad.
Justice.
I'm glad that I do not want the record of this committee to go down in history as anything less than holding him in great admiration. That's very important to me, Senator.
Thank you.
Very important to me.
Justice Scalia, for whom you've also expressed a great deal of admiration, expressed in his other dissent, key one in this case, that Obergefell literally was undermining American democracy, that it was a threat to American democracy. Presumably, he was referring to the fact the court's decision struck down state laws adopted by referenda. What did you understand him to mean? Do you view Obergefell as a threat to democracy somehow?
Senator, Justice Scalia had his views, and he expressed them in his dissent. They're his views. The law of the land is the holding of the Supreme Court in Obergefell.
That's right. Your views you expressed in 2005 in an article in National Review called Liberals and Lawsuits. And in that article, you said marriage equality and death with dignity cases were examples of what liberals relied on an overweening addiction to the courtroom to advance. What did you mean by that?
Senator, we discussed that article yesterday. I'm happy to do it again. And I was pointing out there, I think, two things, and I'd add a third. The first I was pointing out was that there are important civil rights issues that courts have to be available for, and that courts are open to all persons. And one of the beauties of our courts is that they can vindicate civil rights for minorities.
That's right.
It's a non-majoritarian institution.
And the line of cases I've been working through with you are two that are landmark cases but that also have memorable dissents where significant advances in civil rights were made. And that's exactly what I was trying to explore, why you sort of picked out those two areas to, I'll say, denigrate in this National Review article. Maybe I misread it.
I don't mean to denigrate anyone's views, Senator. This was before I was a judge. And the second point I made was that there are some comparative disadvantages to resolving policy matters for courts. One of the disadvantages, comparatively, is that judges are not well equipped to decide policy matters. We have 4 evanescent law clerks that come to us for a year out of law school. Great policymakers, they are not, with all respect to my law clerks. All right? They're wonderful legal researchers, but they're not great policymakers.
Speaking as a former clerk, I appreciate the recognition that some are great legal researchers. I'm not sure I was either a good policy advisor or researcher for my judge.
Right. So,
Let
so
me,
that,
if I can, move to asking you about the basis on which you might ever be open to reconsidering, as Kennedy did of White's decision in Bowers with Lawrence, the decision in Obergefell. Obergefell, which recognized a constitutional right to marriage, equality for same-sex couples rooted in this substantive due process, is something that is now settled law, and on which I'd say there's now a great deal of reliance. One of your core factors, one of the core factors in deciding whether or not a precedential decision should be reviewed. Do you think there's significant reliance interests on Obergefell?
I'm sure there are, Senator, yes.
And would you include in that the thousands, probably tens of thousands of couples that have now married and purchased property and signed contracts and changes in state law and municipal law such that you would agree there's really a significant reliance interest on this decision?
Reliance interests are, as you point out, Senator, an important factor in any consideration of precedent. Absolutely.
And so overturning this key piece of precedent would not just disrespect the now 25-year-long settled mystery of life analysis of Casey and the settled Lawrence decision, but also the reliance interests of many couples in this Obergefell decision.
Senator, I have declined to make any promises, hints, or previews on how I'd resolve any case.
That's right.
And I'm going to continue that here.
But I'm simply asking if you think there's a significant reliance interest.
And I've already
which I think
said
you've agreed.
yes.
Let me just turn, if I might, in the little time I've got left, and we might pick this up in my last round, to an important decision on this same question of 14th Amendment substantive due process right in Browder versus City of Albuquerque. We talked yesterday about your being a Westerner, and this is a particularly Western case in which a police officer going off shift decided to just roar through the middle of town at 66 miles an hour, speeding through 11 different intersections and tragically one red light, killing a person and severely injuring another. The federal access to the federal courts in this case rests on 42, Section 1983. And your own decision, the unanimous decision of the 10th Circuit that you wrote, describes substantive due process, which is the foundation of all these privacy cases we were just talking about, as very much uncharted, more than a little open-ended, a murky area with a paradoxical name. What did you mean by all that in this case?
Senator, a lot of that was quotes from other cases, as I recall.
2 out of the 4, yes.
Oh, all right. From the Supreme Court.
I was a law clerk.
Yeah. And just so we're dead accurate here, I think those are quotes from the United States Supreme Court.
Yes, they are.
All right. I think that's not an insignificant fact to note, Senator.
It's not insignificant.
Okay. And in that case, the question was whether there's a substantive due process right to pursue not a privacy interest, but a lawsuit against, a tort-type lawsuit against a police officer for this conduct. And we have precedent in the 10th Circuit saying, indeed, there is. And in that case, in the majority opinion that I wrote for the court, I upheld the right of the family to pursue the police officer for damages under the United States Constitution.
That's right. And if I might, Mr. Chairman, I have a follow-on question, which we'll get to in the third round.
Okay.
Thank you.
Senator Flake.
Thank you, Mr. Chairman, and thank you, Judge, for your endurance through this process. Yesterday, you mentioned that, quote, all precedents of the Supreme Court deserves the respect of precedent. Let me ask a couple of questions about Supreme Court precedent. One recent precedent was a Hosanna Tabor case. This unanimous opinion affirmed the ministerial exemption to the First Amendment. In other words, the government doesn't have to tell, or doesn't get to tell churches or other religious group how it selects its ministers. Does Hosanna Tabor deserve the respect of precedent?
Yes, Senator.
Thank you. Another recent opinion was U.S. versus Lopez. The opinion involved the Gun-Free School Zone Act. Importantly, the act was passed pursuant to our commerce power. Supreme Court struck down the bill to saying to uphold the government's contentions here, we have to pile inference upon inference in a manner that would convert congressional authority under the Commerce Clause to a general police power of the sort retained by the states. Does U.S. versus Lopez deserve the respect of precedent?
It's a precedent of the United States Supreme Court. That's a weighty thing, Senator.
Thank you. Still one more. Recent opinion in Glossop versus Gross was actually handed down in your circuit, I believe. It involved constitutionality of a death penalty under prohibition of cruel and unusual punishment. The court said, quote, "It is settled that capital punishment is constitutional." Does that one deserve the respect of precedent as well?
It does, Senator.
Right. Is foreign law ever valid precedent in American courts?
Senator, we just discussed this with Senator Sass, and there are instances when foreign law may be appropriately cited. For example, in contract disputes between private parties, sometimes they will have a choice of law provision where they've contracted for the application of a particular state's law or maybe even a particular nation's law. In interpreting the United States Constitution, it's generally not useful for courts to be looking at foreign law. We have our own traditions that are frankly the envy of the world if we want to talk about American exceptionalism. And it doesn't require us to look very far to find our own precedents and our own history that are more germane, usually, Senator.
Thank you. We talked yesterday a bit about being from the West, and in the 10th Circuit, you deal with a lot of issues that aren't brought up as much elsewhere. Public lands issues, disputes, also tribal issues. Can you tell me how dealing with tribal issues has affected your view on religious liberty, or has affected your jurisprudence? I think there was a case, Yellow Bear, Sweat Lodge issue.
Sure. The Yellow Bear case involved a Native American who had murdered his daughter, 3 years old, and was in federal prison, and was denied access to an existing sweat lodge in the prison. And the prison had various reasons why it said it was unable to provide access to the sweat lodge to Mr. Yellow Bear. We applied the Religious Freedom Restoration Act, which was the claim brought. There was no question about the sincerity of the man's religious beliefs. No question that he found solace in his faith after he had done what he'd done. And then the question becomes, if it's a sincerely held religious belief, was it a substantial burden? And that box we checked too, because the prison denied him any access to the sweat lodge. So once you do those two things, the case then shifts to the government, as it does in any RFRA case, any religious freedom restoration case, regardless of who's bringing it, no matter how unpopular, least amongst us. The government has to have a compelling interest, and it has to show that its compelling interest was executed in the most narrowly tailored way possible. And here, the government just couldn't come up with a good reason why it couldn't provide Mr. Yellow Bear with any access to the sweat lodge. It talked about the difficulty of moving him because he was an unpopular prisoner and potentially subject to violence by other prisoners. But the evidence showed that it was able to move him for medical reasons, and able to move him to the cafeteria, for example, and back and forth. And it couldn't show that it was much more, if any, of a burden, financially or otherwise, on the personnel of the prison to also make it a sweat lodge available, at least sometimes. And so our court held that there was a violation of the Religious Freedom Restoration Act in that case, just as we would in any other.
Right. Thank you. Let me shift gears quite a bit here and talk about technology. You mentioned in the Jones opinion on GPS tracking in the heat lamp case, Kylo, in the context of originalism, technology cases provide thorny issues for the court, obviously. You've dealt with some on your own, including the review of Colorado's retail tattletale law, DMA versus Brawl. How should judges approach issues of new technology as it applies to litigation?
Well, Senator, in the first two cases, you're dealing with the question of an unreasonable search and seizure. What's a search? In the Jones case, is it a search to attach a GPS tracking device onto a car? Where does the government, if it is a search, perhaps the government will need a warrant to do that. If it's not a search, it can just do it willy-nilly. And so you have to ask yourself, well, what's a search? Is that a search? And to do that, the court went back and looked at the law of trespass as it was at the time of the founding and concluded that that would be what's called a trespass to chattels, a trespass on your private property, on your, not a physical property, personal property. And that would qualify as a search or a trespass, a property right violation at the time of the founding. And concluded that when we're interpreting the term an unreasonable search, what's a search for the Fourth Amendment, that the Constitution of the United States today can't be less protective now of the people's liberties than the common law understanding was at the time of the founding. That's the way the court reasoned in that case, using existing legal principles to address a new technology. And that's the sort of thing judges do.
How should judges familiarize themselves with new technology? Do we get to leave that to law clerks like we often leave it to staffers to understand new technologies? How important is it?
These are areas where Congress has a role too, respectfully, Senator. New technologies challenge us, all of us. And what's a reasonable search? Guidance from Congress is helpful in that regard. And in fact, I think Justice Alito wrote a separate opinion in the Jones case, inviting Congress's action in this kind of area where we're dealing with new technologies, precisely because of the challenge of trying to address vastly new circumstances, new technologies that we haven't seen before.
You're right. I mean, we deal with that issue here all the time, trying to balance security versus privacy issues. We think that we have it done or balanced, and then new technology comes and upsets it. I'm sure it's the same for the court. But let me continue on this vein, talking about Congress's role as opposed to the judiciary. Mr. Chairman, I'd like to introduce into the record a piece published in Tech Policy Daily called Gorsuch and Tech Policy. And in it, the author, a professor at Boston College Law School, concludes our justices should be willing to work hard and understand new technologies and think critically about how traditional legal concepts map into cyberspace. He concludes Judge Gorsuch's record suggests no reason to doubt that he's up to the task. So that makes us all feel better, I'm sure. But let me talk about this in the context of an issue that we talked about yesterday and has been brought up a number of times. Chevron deference as it relates to innovation here. I don't want to go back to your views on this. There's a great deal, as I said, of exchanges on this subject. But let me talk about the relation to technology here. If judges defer to policy decisions of executive agencies, as Chevron calls for, those decisions depend largely on the public or the policy preferences of the agencies. Is that not right?
Senator, I'm sorry, I'm not sure I entirely tracked the question.
Well, if agencies, if Congress sets a broad policy and the agencies interpret that and write regulations based on that, and the courts defer to the agency interpretation, then policy depends on the policy preferences of the agencies more than it does Congress in that view, right?
That sounds like a reasonable conclusion.
Well, just as an example, if the Bush administration had a policy on a certain technology, and then the Obama administration came in and changed that policy, whether it's the FCC or the FTC, and then it was changed back when the Trump administration came in, that is the technology community out there is kind of whipsawed back and forth. They can't rely on policy. I think that that's why Congress and the courts need to take a hard look at agency deference, and why I think we need to return here in Congress, and this has been discussed over the past couple of days, to legislating on different questions and doing more than we have over the past couple of decades and giving more instruction to agencies on how to interpret, or giving them less to interpret, put it that way. But I do think that we'll have more consistent policy, and policy that the private sector can rely on if Congress has to go through this exercise more than the agencies, because the agencies, it can go back and forth depending on who's in power there. But so I'm just a long way of saying I agree with your what seems to be, and I hope I read it correctly, is skepticism of Chevron deference, and that we ought to maybe tip the balance back toward relying on Congress, or the intent of Congress at least. Mr. Chairman, I'd like to introduce into the record a letter of support from the Hispanic Leadership Fund, which notes Judge Gorsuch has an exceptional record in defending the Constitution and our fundamental rights, such as the Second Amendment and the right to religious liberty.
Without objection, so ordered.
In the time I have remaining, short time, let me just talk a little. You've mentioned in passing about another technology issue, cameras in the courtroom. It's been presented as educational, and maybe people, after viewing this, may have a different view of it. Obviously, we're the legislative branch. Everything we do here should be and always will be in the open and on television. I'm glad C-SPAN is here, and in every hearing just about that we have, with the exception of the intelligence agencies. But when you apply it sometimes to the third branch, you take Trans Am trucking. It's been discussed here at length. It's a pretty boring case when it was a cameraless courtroom that heard it. It was about standards of administrative review, statutory interpretation. But now, in this hearing room, it all of a sudden becomes a battle between the big guy and the little guy. And I think that there is a legitimate concern about opening up our courtrooms to cameras and what that will incentivize. So I hope that you've said that that's something that you will look at, as will everyone on the court. But I hope that, that we pause as we do so. And watching these hearings over the past couple of days, I hope will give us some more pause about cases that don't lend themselves well when you consider what Edmund Burke said about the cold neutrality of an impartial judge being the standard. That sometimes, to me, seems inconsistent with cameras in the courtroom and what that incentivizes. And so with that, Mr. Chairman, and with the thanks of a lot of endurance, like I said, over the past couple of days, and you still have more to come, but I yield back.
I'm surprised you're such a reasonable senator, you'd be against cameras in the courtroom. Senator Blumenthal.
Thanks, Mr. Chairman. I want to take issue with my good friend from Arizona and state, as I have before, how strongly I feel that cameras in the courtroom, including in the United States Supreme Court, would be a very good thing. I know the chairman agrees with me, as do other members of the committee, and I believe that the American public would be better informed about the work of the court and about their rights if more of the proceedings in our federal courts were better known to them. I think that the image and the performance of our attorneys, of juries, of judges would not only attract interest but also elevate the performance there. So I hope you'll take that under advisement.
Senator, one thing I've really gotten out of this process that I didn't fully appreciate, I knew the advice consent function worked between Article 1 and Article 2, and I've been asked to comment on that, and I won't, but I've learned a lot, and I appreciate the advice I've gotten, thoughtful advice on a number of issues from senators across the spectrum. You are thoughtful people who care deeply about this country, and you care deeply about the judiciary, and I appreciate that, and the input that I've received from all of you. Thank you.
Well, I very much appreciate that statement, and it leads to my next observation, which is about this process. As much as there's been some hand-wringing and some doubt expressed, I happen to think this kind of process is a lot healthier for our democracy than the 90 minutes that our common mentor, Justice White, spent in your place. And I think, actually, although I don't know him, did not know him as well as you, but I did see him on occasion on the basketball court in the highest court of the land and had occasion to observe his elbows.
Did you get one? Did you get one on the side?
I know that I have a right to remain silent. But I think he would have enjoyed the give and take.
He enjoyed physical contact in any sport and activity, and you may be right. You may be right about that.
And I appreciate your being here to answer all our questions, and as I said yesterday, your patience and perseverance. I also...
Senator, I consider it a privilege to be here with you.
Thank you. I also want to raise a question talking about court procedure relating to conflicts of interest and ethics. I think you were asked yesterday about the proposed ethics rules that have been applied to your court,
Yes.
to the appellate court, to the district court, but not to the Supreme Court. And would you view such legislation as a violation of the separation of powers?
Senator, I'm afraid I just have to respectfully decline to comment on that because I'm afraid that could be a case for controversy. And you can see how it might be. I can understand Congress's concern and interests in this area. I understand that, but I think the proper way to test that question is the prescribed process of legislation and litigation.
I assume that you have observed all those rules as a member of the 10th Circuit Court of Appeals.
I've done my best, Senator.
Have they been unduly burdensome?
No, Senator, no.
Have you found that they interfere at all with your discharge of duties as a judge?
No, Senator.
Would you object personally to following those rules as a member of the United States Supreme Court?
My personal views, Senator, have nothing to do with my job as a judge.
Will you commit to following those rules personally on your own without any legal requirement?
Senator, what I've committed to do is to take a look at the law, talk to my colleagues collegially, and then make up my own mind. And I'm taking into account all the advice I've gotten in this process carefully. I will carefully consider that. But, Senator, I'm not going to make any promises in this process to anyone about anything other than to be the best possible judge I can be.
Well, I hope that you will be as persuasive as possible after you make up your own mind, and hope that you will decide that these rules make sense, because, again, in terms of the appearance and the trust and credibility of the courts, I think that they are important. I want to go back to some questions I asked you yesterday, which perhaps you didn't get a chance to clarify, and I want to give you that opportunity. You recall we were talking about Brown v. Board of Education, and you said, I believe, that you agree with that decision. Do I have it correctly?
Senator, it is a seminal decision of the United States Supreme Court interpreting the 14th Amendment, maybe one of the great moments in Supreme Court history.
You said, and I quote, that it corrected an erroneous decision, a badly erroneous decision, end quote, and you called it, quote, a correct application of the law of precedent, end quote. And you said also that it vindicated a dissent, quote, that got the original meaning of the Equal Protection Clause right. That sounds to me like you agreed with the result in Brown versus Board of Education.
Senator, you can characterize it however you want. I've said what I've said, and I stick by what I said.
So unlike Justice Kennedy and Justice Roberts, Chief Justice Roberts, in their confirmation hearings, you will not say that you agreed that it was the right result.
Senator, I've said it's a seminal decision of the United States Supreme Court that corrected a badly erroneous decision, that vindicated the original understanding and the correct original meaning, rather, of the 14th Amendment, and is one of the shining moments constitutional history in the United States Supreme Court. That's what I've said.
So why will you not say that you agree with the result?
Senator, I don't know what it means. I'm not sure what we're arguing about here.
We're not arguing. I'm
Okay.
just asking why you are so averse to saying, yes, it was the right result.
I'm saying as a judge, it was a seminal decision that got the original understanding of the 14th Amendment right and corrected one of the most deeply erroneous interpretations of law in Supreme Court history, Plessy versus Ferguson, which is a dark, dark stain on our court's history. And it took way too long for the United States Supreme Court to get the 14th Amendment right. It's an embarrassment in our history. That's what I've said, Senator.
And Chief Justice Roberts, in response to Senator Kennedy's question, quote, do you agree with the court's conclusion that the segregation of children in public schools solely on the basis of race is unconstitutional? Then Judge Roberts, quote, I do. You said yesterday, and I'm quoting you now, that there's no daylight between you and
Respectfully, I don't see any daylight between what I've just said and what you've just quoted from the chief.
Okay.
I just don't, Senator.
I'm not going to dwell
We're
on
on the
this.
same page on Brown versus Board of Education, Senator.
Okay.
It's a great
Well-
and important decision.
Would you say the same about Griswold versus Connecticut?
What I've said about Griswold versus Connecticut, Senator, is that it is a decision by the United States Supreme Court recognizing the right of married couples in the privacy of their own home to use contraceptive devices. It was decided, I believe, in 1965, though Senator Franken may wish to correct me.
No, you're right about 1960.
All right, good, all right. 1965.
And if I'm wrong, I'm not going to tell you I'm wrong. It was decided in 1965.
1965.
That was its holding.
Yeah.
And I'm asking you, do you believe it was the right result?
And what I've said is, Senator, it's 50 years old, more than 50 years old, right? The reliance interests surrounding it are obvious and strong. It has been repeatedly reaffirmed. Those are powerful things in the law of precedent. I've also said I cannot imagine a state trying to pass a law in this area, and I've said I cannot imagine the United States Supreme Court taking such a law seriously. I don't know how clear I could be to you, Senator.
You could be much more clear about your personal beliefs.
Right. And
You
my
believe-
personal views have nothing to do with my job as a judge.
Well, let me invoke your beliefs as a commentator. Do you believe it was the right result based on your understanding of the law? Not your personal beliefs about whether contraceptives are a good thing or a bad thing, but your beliefs about the constitutional underpinning, the right to privacy, the Fourth Amendment, substantive due process underpinning of Griswold versus Connecticut. Was it the right result?
Senator, I have consistently, I'm not picking out Griswold or any other particular case. I've drawn a line that I think is required of a good judge to be fair and to respect the separation of powers without respect to precedent. A precedent of the United States Supreme Court, as we were talking with Senator Flake, they're all precedents. They all deserve respect of a judge, a
But
good
some
judge.
more than others.
Senator, it depends upon the factors under the law of precedent, what weight you give a precedent.
Why is your-
I'm
sorry.
Including the age of the precedent, how often it's been reaffirmed, the reliance interests surrounding it, whether it was correctly decided, whether it's constitutional versus statutory, and a number of other things that we've discussed repeatedly.
And you're saying that there is no threat of it coming before the court because a state legislature is unlikely to pass the kind of criminal ban on contraceptive use that existed then.
I have said, Senator, that with this particular precedent we're talking about, that it's over 50 years old, weighty factor, that the reliance interests surrounding it are obvious and many and great. I have said that it has been repeatedly reaffirmed by the United States Supreme Court. I've said that I cannot imagine a state actually legislating in this area. And I have said that I cannot imagine the Supreme Court taking a challenge, someone wishing to challenge that precedent seriously. I don't know how much more clear I could be to you, Senator, as a judge.
Would you say the same about Eisenstadt v. Baird?
I have already, Senator, several times in the course of this hearing.
And you are unwilling to do as Justice Alito did, and he was a judge, and I think you would probably say he was a good judge, correct?
I think every member of the United States Supreme Court sitting is a very fine judge. Yes.
And he said about Eisenstadt v. Baird, I do agree with the result. You're unwilling to say that, and you're unwilling to say, as Chief Justice Roberts did about Griswold, I agree with the Griswold Court's conclusion that marital privacy extends to contraception and availability of that.
Respectfully, Senator, I think we're splitting hairs. I really do, because I've told you quite clearly that both of those precedents are in the realm of 50 years old, that they have serious reliance interests around them, that they've been repeatedly reaffirmed. And Senator, what I've tried to do with respect to all precedents is treat them equally in my presentation before you, because as a judge, I come at them equally. In my line of work, a precedent is a heavy, a weighty thing, and it deserves respect as precedent, as part of our history. And
well,
for a judge,
we are doing more than, with all due respect, Your Honor, we're doing more than splitting hairs here, because words matter. And the words of Chief Justice Roberts and Justice Alito's were different than yours. Asking you to agree that these results were correct, I think, is a relevant and important question. And you're declining to do so. I respect your reasons, but I think that it speaks volumes, with all due respect.
well, let me try it one more this way, Senator, for you. Maybe this will help. The way I look at it is, I don't come at these issues fresh. It's not whether I agree or disagree with any particular precedent. That would be an act of hubris. Because a precedent, once it's decided, it carries far more weight than what I personally think.
Well, let me ask you.
The point of a precedent, I'm trying to be as helpful to you as I can be here, Senator, is that it represents collective wisdom. And to say I agree or I disagree with the precedent of the United States Supreme Court as a judge, that's an act of hubris that to me just doesn't feel like a judicial function. For a judge, precedent is more important than what I think. And my agreement or my disagreement with it doesn't add weight to it. It is what it is.
Let me ask you about Loving versus Virginia. As you know, it invalidated bans on interracial marriage under both the Equal Protection and Due Process Clause. Do you agree with the result there?
Seminal, important application of the principles recognized in Brown versus Board of Education, and a vindication again for the original meaning of the Equal Protection Clause, that all of us, every single person, is equal, and that we can all choose with whom we wish to live our lives without respect to race. It's one of the great moments. We've visited some dark moments in Supreme Court history, and we've visited some bright moments, Senator.
And Lawrence versus Texas, which held that the government can't criminalize gay and lesbian relationships?
That's a holding of the United States Supreme Court, due all the weight of precedent, Senator, as well.
And would you agree that it overturned an incorrect decision in Bowers?
That is what it declared, Senator. That is the precedent of the United States Supreme Court.
Do you agree?
Senator, it's the precedent of the United States Supreme Court. I'm going to give you the same answer every time.
Well, I suspect you will.
Yeah.
But let me just say that the answer that you have given leaves doubt in a lot of minds. And to quote from a concurrence by Justice Kennedy, as well as Justice Souter and Justice O'Connor, and I'm quoting, "Liberty finds no refuge in a jurisprudence of doubt." You're declining to be more direct and give the same answer about these cases that you did about Brown leaves doubt in the minds of millions of Americans who rely on privacy rights. They are relying right now. And I think that that doubt is regrettable. I want to ask you, I think I know the answer. Do you agree with the result in Roe v. Wade and Planned Parenthood v. Casey?
Senator, I'm drawing the same line that Justice Ginsburg drew, Justice O'Connor drew, Justice Souter, Justice Scalia. Many, many, many people to sit at this confirmation table have declined to offer their personal views to this or that precedent, whether it's one side's favorite or another side's favorite, one side's least favorite, the other side's least favorite. We've gone back and forth today on precedents, which ones people like and don't like. And I understand that every citizen and that every member of the Senate has their precedents that they prefer personally and not. I understand that. I respect that. That's part of the process and our First Amendment liberties. But as a judge, my job is to decide cases as they come to me. And if I start suggesting that I prefer or not dislike this or that precedent, I'm sending a signal, a hint, a promise, a preview, as Justice Ginsburg called it, about how I'd rule in future cases where those principles from that case are going to be at issue. And all of these cases that we've just discussed, they're very live with controversy, as you know, Senator, which is why you're asking about them. And for a judge to start tipping his or her hand about whether they like or dislike this or that precedent would send the wrong signal. It would send the signal to the American people that the judge's personal views have something to do with the judge's job. And the one thing I've tried to convey over the last 3 days is that I don't believe that's part of the judicial function. And I don't believe that's what good judges do. And I've also said, Senator, and I believe this firmly, that once a judge starts committing, promising, hinting, previewing, forecasting, agreeing or disagreeing with precedent at this confirmation table, we're in the process then of campaign promises. And we're in that process, Senator, I fear, of judges having to make commitments, tacit promises, hints, previews, as Justice Ginsburg called it, in order to become confirmed. And once we do that, I'm fearful for the independence of our judiciary.
Well, just for the record, because I'm out of time, I'm not asking you to look forward to cases and controversies that may come before you. I'm simply asking you whether you accept the basic core principles of the right to privacy that are articulated in those decisions. I apologize, Mr. Chairman, that
No.
I've gone over by a couple of seconds.
No, that's fine. Before Senator Crapo, we have a vote sometime between 4:45 and 5:15. The exact time, we don't know. But when that'd be a good time for us to have the break, to move to our closed session, and then come back here, and whoever has not had their second round yet will get their second round, and then we'll immediately go to the third round. Senator Crapo.
Thank you very much, Mr. Chairman. And Judge Gorsuch, I want to go back to the issue you've just been discussing. First of all, to say that I respect your absolute resistance to being invited to put your personal opinions onto the issues that you will need to face as a Supreme Court justice if you are confirmed. I appreciate it and I respect it. The fact is that, as now Justice Ginsburg said, if you can be pushed into giving hints about what your feelings are about the precedent of the United States Supreme Court decisions or other cases, then you will have violated what I think is an appropriate approach that a judge should bring to jurisprudence. And so I just wanted to tell you I appreciate, I know you're getting questions again and again and again, and you consistently make it very clear that you're leaving your personal opinions out of it, as a judge should do. So I for one, want to tell you that I appreciate that and recognize it. That leads, though, to one of the issues that I wanted to return to with you. You and I talked about it yesterday, and in fact, you've talked to a number of senators about it, and it's back again to the question of originalism and textualism. And I realize that it's hard to put labels on this issue because they don't really necessarily portray what it is we're trying to talk about. But the aspect of this that I would simply like you to discuss a little more in detail is the one really that Senator Feinstein started out with today. If it is, and I don't want to put words in your mouth, but if it is the approach that a judge or a justice should take, that they look at the Constitution or a statute as it was written and try to determine what reasonable people would understand it, the words in the statute to mean, does that mean that somehow for all time in the future, as society evolves and as science evolves and as circumstances develop that were not contemplated perhaps at the time the Constitution or the statutes were written, does it mean that we don't have a way to deal with applying those laws or the Constitution to new circumstances? And does that, if the answer to that is no, that there is a way to apply these laws and to interpret the Constitution, does that mean that we are somehow changing the Constitution? Or what are the parameters of that entire concept? Could you discuss that a little more completely?
Well, Senator, we've discussed this quite a lot. I'm happy to try to do it again. But the job of a judge is not to make law, but to interpret the law and to apply the law as best as humanly possible. And one way to do that, we start with precedent. That's where we start. We don't reinvent the wheel. And we apply the precedent we like and the precedent we don't like, because our personal views have nothing to do with our job. We apply all the precedent. And if you can't do that, well, then you're in the wrong line of work. A judge's job is to apply precedent without respect to persons and without respect to their personal views. Then when we look at, say, an unanswered question where there isn't precedent, for example, one thing a good judge will want to know is what the original understanding of that law was at the time. In the statutory context, I've talked about the Fish case. Mm-hmm. In the constitutional context, I've used a couple of cases that I think are good examples. One is the thermal imaging case, and the other is the GPS tracking device case. Those are some of my favorite teaching cases when I go talk to young people about these issues. And the point of them all is to demonstrate two things. That when we speak about the original understanding of the law, we're protecting due process interests. We're applying the law as we could expect a reasonable citizen, person, in this country to have understood it. So that when I'm putting a person in prison, for example, which we do as judges, we're complicit in that process, that I know I'm putting that person in prison for something that they could reasonably be charged with, knowing to be improper. Not something that comes from my heart, that I've made up, not my personal views, not what I like or dislike or agree with or disagree with, but what I can say that person should have known. That's the due process fair notice value. And the other aspect of it is the separation of powers value that's behind this, which is, again, I can make a reasonable claim that I'm declaring what the law is, a reasonable claim that I'm not just doing politics, a reasonable claim that I'm trying to interpret and apply rather than alter and amend the work of the people's representatives. For after all, this is a democracy at the end of the day. It is not an oligarchy of judges.
I think that's an important distinction that you just made. You're trying to interpret and apply rather than to alter or amend the meaning of the Constitution or the words of the Constitution or the words and meaning of a statute. And to me, that is really the core issue here, that what I hear you saying is that your objective, whether it's called originalism or textualism or what have you, is to identify what a reasonable person would interpret the words in the Constitution to mean, and not to say or to try to interpret it to mean what you think they should have said or written at the time, which does not mean that you cannot apply those principles to new developments in society or in science. It simply means that you must interpret the words as they were intended and as reasonably understood. And if we are to change it, then there is a process for that to take place.
That's right, Senator. And that process lies with the people's representatives or the amendment process, as we've discussed. Exactly. Yeah.
Thank you. One other question that I have in this round, and I don't intend to mean by that I will call for another round, but I'd like to talk with you for a minute about the concept of independent agencies that you briefly discussed with Senator Sass. As I understand independent agencies, they are basically agencies of the United States government. They are in the executive branch, as you indicated, but they are independent. And there was, perhaps you could go through with, you're aware, I'm pretty sure, of the Myers case and then the Humphreys executor case. I think you referenced the Humphreys executor case earlier. Could you just explain what those two cases tell us?
Well, Myers initially suggested that, and I think it's a fair reading to say that it cast doubt on the proposition whether there could be an agency whose head would not be subject to removal by the president. It will. And Humphrey's executor overturned Myers and held that that was indeed proper. Of course, the court has more recently also re-entered this area in the Peekaboo case and indicated that while one layer of for-cause removal protection is appropriate, 2 layers crosses a line.
Explain to me, I'm not as familiar with the Peekaboo case exactly.
Sure. So Humphrey's executor says that you may have an agency, a multi-member agency, where the head of it is removable only for cause. Mm-hmm. These are gross generalizations.
I understand, and I ask you only to be
right.
General in your description.
And I'm not signaling my agreement or disagreement with anything. I'm trying to faithfully report to you the precedent of the United States Supreme Court.
Understood, and that's the question I asked.
And the Peekaboo case is a more recent case in which there were 2 layers of for-cause removal. And whether the question whether that was constitutionally permissible, consistent with Article 2 and the statutory structure. And the Supreme Court said 2 layers is too much, 1 too many.
And what was the second layer? Was that congressional oversight?
2 layers, no, 2 layers of for-cause removal. So,
oh, I see.
Yeah.
So the notion is that even after Humphrey's executor and Peekaboo, there still are limits to the amount of independence that Congress can give to an agency.
That's what the Peekaboo case basically says, yes.
Well, I think I'm going to leave it at that. there are a lot more aspects of that I'd love to discuss with you. But obviously, the notion of understanding the importance of the three separate parts of government that our Constitution created and the potential that this line of cases has of allowing Congress to create a fourth branch that is not responsible to either or maybe any of the other three branches is troubling to many of us. And so it's just an important area that I wanted to get your general understanding of. I won't ask you to opine on it or to give your personal opinions.
I'm grateful for that, Senator. It is, Humphrey's executor is a precedent of the United States Supreme Court, and you know, I understand that some people like it and some people don't.
Understood. Like I said, I have a lot more questions, but I'm not going to use up any more of your time or mine in this round.
Thank you, Senator. Senator Hirono?
Thank you, Madam Chair. Judge Gorsuch, it's good to see you again.
Likewise, Senator.
Despite the many hours that you've been before us, I still feel like there's much more we need to know about you and what kind of justice you would be. And I still need reassurances that you will be the kind of justice who is open to applying the law and the Constitution to protect the rights of the working poor who are just one paycheck away from being homeless, who understands the importance of ensuring that victims of discrimination can not only ask for, but can also receive protections from our courts, and who demonstrates a commitment to the constitutional principles that protect the right of women to make the intimate and personal choice of what to do with our own bodies. So I'd like to try again with you today. You painted a picture of, for us yesterday of the court that is straight out of a Norman Rockwell painting. You said, and I quote, "One of the beautiful things about our system of justice is that any person can file a lawsuit about anything against anyone at any time, and a judge, a neutral and fair judge, will hear it," end quote. This is a wonderful idea, that anybody can file a claim to protect their rights or interests, and that those claims will be heard and ruled upon by neutral judges, apparently uninfluenced by their own strongly held and frequently expressed personal views and judicial philosophy. But of course, you and I both know politics and the courts are intertwined. In fact, you told us so in your 2005 National Review online article, which was entitled, quote, "Liberals and Lawsuits," end quote. In that article, you wrote that as a result of Republican wins in the presidential and Senate elections, Republicans were in charge of the judicial appointment process. As a result, you wrote, quote, "The level of sympathy liberals pushing constitutional litigation can expect in the courts may wither over time, leaving the left truly out in the cold," end quote. This shows you understand, or at least recognize, that judges appointed and confirmed by Republicans will have less sympathy for liberals pushing constitutional litigation, as you put it. I am profoundly troubled by this, because I thought judges, as you described, make decisions divorced from their personal and philosophical leanings. So should justice depend on who won the last election, or who is in charge of nominating and confirming judges?
Senator, I appreciate the opportunity to answer that question because I've tried to make clear as I can over the last few days that I don't view my colleagues as Republican judges or Democrat judges. I view them as judges. And I believe that the courts are open to all persons. And I believe if you look at my record as a judge, as opposed to anything else, you're going to see that I've decided over 2,700 cases, that 97% of the time they've been unanimous, that 99% of the time I've been in the majority, that according to the Congressional Research Service at least, my opinions have attracted the fewest dissents of any 10th Circuit judge they studied.
Judge Gorsuch,
Those
if I
are,
may.
of course.
I am listening to your answer, and I am not getting a response to the question I asked, which was, I'll ask it again. Should justice depend on who won the last election or who is in charge of nominating and confirming judges? And I think that requires a yes or no answer from you.
And I don't think it does, Senator, as I've tried to express. I don't think when you come to the 10th Circuit, you come to my court, I would think it would be deeply wrong to suggest that it depends on who won the last election, what kind of justice you're going to get in my court. It's not the way it happens. And I know the men and women of the federal judiciary, and I know how hard they work, how lonely the job is often, how much criticism they attract from all sectors. And I know that when they wake up in the morning, they do so with one thing in mind, to be a fair and independent judge for each case that comes to him or her. That's what I know. That's what I've seen. That's what I've witnessed. I know the men and women of the federal judiciary. I know a lot of them, and I admire them. And I don't think it matters whether they're Republican or Democratic appointed judges. No.
That doesn't square with the view that's expressed in the article wherein you acknowledge that the people in charge of the judicial nomination and confirmation process will or may result in, if it's the Republicans, less open to liberal views. So how do your views in that article square with what you're telling me right now?
Senator, I appreciate the chance to talk about that article again. We've chatted about it a few times the last couple of days. And as I've tried to explain, I made a couple of points there. First was that the courts have to be open to civil rights claims. They're very important for vindicating the rights of unpopular voices, minority voices, the least amongst us. That's what courts are for. But I also made the point that sometimes social issues, problems of the day, are not best resolved in the courts because the courts have certain limitations. One, we're just not very good at making social policy. I've got 4 law clerks straight out of law school. With all respect to them, I love them, but they don't know a lot. All right? You have staffs for making social policy. This is the place of the people's representatives. We're not a democratic institution. We're life tenured judges. I wouldn't hire a bunch of life tenured judges to run a country, with all respect, and call it good. There's a separation of powers. And so the point was, the other point I was trying to make there was judges, somebody has to win and somebody has to lose. There's no room for compromise. And one of the things this body is really good at its best, is compromise, right? That's what you do in legislation.
Yes.
There's a give and a take, a pull and a tug, right? And it's not present in litigation. So those were some of the points I was trying to make in that article.
I believe I'm trying to have more of a conversation with you, and in fact, I'm glad that you acknowledge that judges are really bad at the compromises that result in legislation. So I actually have a question about that later. But, you know, you drew a conclusion in your article about the impact of Republican wins in the elections, and I think that that was a really astute observation. It was a real-world conclusion. And as we exercise our advice and consent role, the judicial philosophy of the judges who are nominated matters a great deal in determining what rights and whose rights are protected in the courts. As you say, there are winners and losers. So, Judge Gorsuch, you clearly understand that our political system has a tremendous impact on the courts. If not, we would have Chief Judge Merrick Garland before us, not you. You also understand the impact of politics on protection of our rights, or rather, again, as I said, on what rights and whose rights are protected. And again, in your 2005 National Review article, you admonish liberals for seeking to protect their rights in court rather than through the political process. And you wrote, and I quote, in part, "It would be a very good thing for all involved, the country, an independent judiciary, and the left itself, if liberals take a page from their own judges of the New Deal era, kick their addiction to constitutional litigation, and return to their New Deal roots of trying to win elections rather than lawsuits," end quote. And of course, since you wrote your article, the Democratic nominee for president did win the popular vote in all 3 presidential elections, including the last one. So you describe the left as being addicted to constitutional litigation. But we all know, of course, on the right, we have seen well-funded groups looking for plaintiffs to bring lawsuits to advocate a corporate agenda. And there's little doubt. Let me just go over one example of the right looking for plaintiffs. In Fredericks, conservative lawyers sought to challenge the 40-year-old rule established unanimously by the Supreme Court in Abood that all employers represented by a union, including those choosing not to join the union, must pay for their representation. Overturning Abood would unquestionably hurt unions. And the challenge to this 40-year-old precedent did not appear from nowhere. It was, in fact, invited by Justice Alito in his opinion on another case ruling against unions. And while the attempt in Fredericks failed, when the 4-4 Supreme Court left in place the Ninth Circuit decision, I am sure we will soon see another well-funded attempt. And in fact, there's little doubt that Justice Scalia or someone like Justice Scalia would have ruled against the teachers' union in that case, and it would have been a 5-4 decision. In your article, why did you aim your criticism at the left and not to constitutional litigation from the right? What does that focus tell us about how you would assess such lawsuits if you are confirmed to the Supreme Court?
Senator, I thank you for the opportunity to address that. As I have indicated, I think probably 5 or 6 times in the course of these hearings the last couple of days, I was agreeing with a self-described liberal commentator on his own assessment, a Washington Post columnist. I was agreeing with his assessment. And I also have explained that, and I explained 10 years ago when I was before this body last time, that I've seen plenty of examples on both sides and really across the ideological spectrum of lawsuits that maybe perhaps better belonged in front of legislators.
Well, as I mentioned, I thought that was a very astute observation and agreement on your part that that politics do enter into who becomes judges and who becomes appointed and confirmed. In fact, the Roberts Court has issued numerous 5-4 decisions in cases like Lilly Ledbetter, Citizens United, Hobby Lobby, in which corporate interests went out over individual rights. And clearly, the composition of the court and identity of the 5th justice, a Justice Garland versus a Justice Gorsuch, does matter a great deal in the real world. Your article reflects also a suggestion that the courtroom be used only for extraordinary cases. Now, this doesn't square with what you told me yesterday, that the beauty of our system is that anybody can file a claim and be heard. Who decides whether a claim is extraordinary enough to be to seek justice in the courts?
Senator, with respect, I don't recall ever using the words that courtrooms only for extraordinary cases. That doesn't sound like me.
It's in the article that I'm talking about where
I would be surprised to hear that I said that courtrooms are only for extraordinary cases. I represent a lot of people in a lot of pretty ordinary cases as a lawyer. As a judge, I resolve a lot of pretty ordinary cases in the sense they don't make a lot of precedent or don't get a lot of attention, but matter deeply to the individuals involved.
Judge Gorsuch,
That's part of what a good judge does, part of what a lawyer does.
I just read the article that I'm quoting, and frankly, what you set forth in that article, Liberals and Lawsuits, I think has definitely endeared you to the Heritage Foundation and the billionaires who recommended you for this position. Frankly, courts should not depend, of course, on who won or lost the election. It should depend on judges who understand that the law is there for all of us. And I do remain concerned about that is really how you view the law. When we look at the relationship between politics and the courts, I'm deeply concerned about the decision the court itself, the Supreme Court itself has made, which has tilted the political field so significantly. And this impacts both the laws we are able to pass, and the composition of the court that in turn is supposed to interpret and apply those laws in the cases that come before the court. I'm sure you're as familiar as I am with Justice Felix Frankfurter's famous admonition that, quote, courts ought not to enter this political thicket, end quote. But of course, there are times when the court must do so, for example, to ensure one person, one vote. But courts also must be careful in doing so, getting into the political thicket. The court's legitimacy itself is at risk when it strays too far into the political thicket, such as by deciding an election such as it did in Bush v. Gore. In the last few years with the Citizens United and Shelby County decisions, we have seen the tremendous, in my view, damage the court can do to our political process when it tilts the electoral process so heavily against ordinary Americans. And as we discussed yesterday in the 2010 Citizens United decision, the court struck down bipartisan laws limiting campaign contributions that went back more than a century and opened a flow of money and potential corruption that has dominated our politics and drowned out the voices of ordinary Americans ever since. And in 2013, the Roberts Court, in another narrow 5-4 decision in Shelby County, substituted its conclusions for that of Congress and gutted core protections of the Voting Rights Act, which were essential for the right to vote for millions of Americans. So taken together, these two decisions, Citizens United and Shelby County, have made it harder for millions of Americans to have their voices heard in our elections process and their votes counted at the ballot box. Since Citizens United, the floodgates have opened to unfettered corporate money in our elections. Since Shelby County, 13 states have enacted laws placing limitations on voting. And many of these are in the states that would have been prevented from passing such laws in the first place before the court gutted the Voting Rights Act. And after Shelby County, they could pass such laws, and pass them they did. So given your clear understanding of the relationship between the political process and the courts, would you acknowledge that these decisions, Shelby County and Citizens United, have had an impact on our elections?
Senator, they're precedents of the United States Supreme Court, and obviously they have impacts.
Would you acknowledge that elections have an impact on the composition of the court?
Senator, again, I would say that there aren't Republican judges or Democrat judges. There are judges. In my experience, there are fair judges appointed by Republican presidents and Democratic appointed judges. And people surprise you from time to time, Senator.
Well, clearly, elections have an impact on the composition of the court because we have you. We do not have Judge Merrick Garland. So would you acknowledge that the composition of the court influences the decisions that it makes?
What do you mean by that, the political composition of the court, Senator?
No,
Sorry.
The composition. I didn't say political composition. Would you acknowledge that the composition of the court influences the decisions that it makes?
Well, I do think each individual member of a court impacts a court in the sense that when I get a new colleague and an old colleague retires, there is a new dynamic with that new person. They bring with them fresh eyes from practice and maybe some new ideas, and maybe they also need some time to come up to speed in other things. Every person's different. I'll acknowledge that, of course.
So yesterday, in response to my concerns about the impact of Citizens United, your narrow reading of OSHA, and your expansive view of the Religious Freedom Restoration Act, your answer was that Congress has latitude to act and legislate. But by tilting the political playing field so heavily toward corporations and against individuals, hasn't the court impacted the composition of who is in Congress and made it therefore even harder for Congress to take meaningful action to, say, pass laws to protect worker safety or the access of students with special needs to an education?
Senator, the Supreme Court of the United States, I wasn't involved in these decisions that we're discussing. I wasn't there.
However, they are precedent. that
They
you
are
continue to
precedent,
cite.
and I have to follow them, and I respect them as precedent.
Yes.
Precedent of all kinds has impacts, of course, and it's obviously for this body as the lawmaking body to assess what it thinks of the impacts of any judicial decision and to legislate appropriately. And we do our job, and respectfully, Senator, the Congress does its job.
Well, Judge Gorsuch, the court isn't an innocent bystander here. You have set forth a magical notion of what Congress can do and legislate. I wish you were right. I would love for all of us to be able to work together in a way that moves us forward for our entire country. And you did acknowledge yesterday that passing legislation is not easy. In fact, you acknowledged that today. For example, Congress, in passing the Voting Rights Act reauthorization in 2006, held 20 hearings and gathered over 40,000 pages of evidence, and yet the Supreme Court substituted its own judgment to sweep all that away, eliminating a core part of the Voting Rights Act, which Congress had concluded and experience in the last election has now proven was still needed. In doing so, this decision has had a real-world impact, changing who gets to participate in the political process, and therefore who gets elected and who has input in the kinds of laws that are passed, and indeed who gets nominated to the Supreme Court. I yield 15 seconds, Mr. Chairman.
Thank you very much. What we'd like to do, we have two people left. According to the message we got from the Senate, we'll have a vote at 4:50. So I'm hoping you two folks will get done, and if you ask questions that's never been asked before, we'll get done really on time.
With you pointing that gavel at me, I'm pretty sure I will.
And
That was a subtle hint from the chairman.
so I would ask you two to finish, and then we'll go vote at 4:50 or whenever
Yep.
you two are done, and then we'll reconvene, hopefully by 5:20 and 2:26 for our closed session.
Well, Mr. Chair, I hope to keep my streak alive, yielding back about 5 minutes in each of the prior two rounds. And
Praise the Lord.
I want, we've heard all the discussions about the precedents, and there are clearly ones that some of the members want to pick and choose that they like, and ones that they want to pick and choose that they don't like. Do you have that option as a judge?
I understand the impulse,
Yeah.
Senator. It's a human impulse.
Sure.
And as the people's representatives,
Yeah, but do you have that option?
I don't have that option.
That's what I
Senator, I'm a
thought.
judge.
That's what I thought. I mean, the law is the law.
That's right.
And you've got to follow it, and it's got to be instructive.
That's right.
Which is another reason why it's inappropriate. Would you consider it an inappropriate question for me to get you to answer a question that would be in violation of the Code of Conduct for United States judges? Would you consider that an inappropriate question?
Senator, questions aren't inappropriate. Answers would be inappropriate. I'm the one who's bound by my code of conduct.
You're a kind man. That's why I'll never be nominated for the Supreme Court. There's a lot of reasons, but that's one of them. Overnight, I decided to go out. I don't know why I do, because reading press reports is a lot like roadkill. You try to avert your eyes, but then you go back and look at it. So I looked at the roadkill of the overnight press, and of course there were people saying you sidestep issues. These folks don't get it. They realize that you were following a code of conduct and you answer the questions to the best of your ability within the guidelines that you as a judge have. You were a judge on the 10th Circuit, and I think you did it well. So I think any reporter out there, like a lazy blogger from McClatchy who reported you sidestepping questions, you haven't sidestepped a single one. You've answered every one to the best of your ability within the guidelines that you have as a sitting judge. And I appreciate you doing that. And I appreciate your consistency, even when some of my colleagues may have got you to answer one you knew. You were consistent. There was never an instance over the course of these last 3 days where you wavered, and I, for one, I'm glad that you did that. You ever see the movie Jeremiah Johnson?
I haven't, Senator.
It's a great movie. It was filmed, I think, out in Utah, and Robert Redford, and I think Will Greer was the old codger. A lot of this discussion over the past couple of days reminds me of a great scene in Jeremiah Johnson. Jeremiah and Will Greer decide they meet up in the high country, and the old I think his character was Bear Claw. said, you know, I hate skinning bears, but I don't mind hunting them. And Jeremiah Johnson was relatively new to the high country. He says, I'm scared of hunting bears, but I don't mind skinning them. So they go to bed at night with the understanding that Bear Claw would go out in the morning and that the Jeremiah Johnson would stay behind and skin the bear once he got one. And early in the morning, there's this great sunrise, and Bear Claw is running through the woods, and right behind him is this huge brown bear. He runs up to the cabin. He jumps into the window. The bear jumps in with him. He runs out the front door and shuts it and says, there's one for you. I'll have another one shortly. Well, that's what Congress is doing to the Supreme Court and to courts across this country. We're not properly hunting the bear. We're not living up to that expectation of actually producing a bear where we've taken care of the things that we should have before you had to skin it. Your job is to determine whether or not it passes constitutional muster, whether or not it passes the legal test based on decisions that we've made here. For example, in Hobby Lobby, you mentioned had the Affordable Care Act been exempted from RFRA, it probably would have produced a different result.
One sentence in the statute.
Yeah. Well, you would think that the sponsor of the RFRA bill in the House, now Minority Leader Schumer, would have remembered that bill. It was a pretty consequential bill. So you would think that they would have taken the time if they wanted to exempt it. I think I believe he's a good attorney. He would have known that, and he would have exempted it. So they left you no other choice because they didn't skin that bear if that's in fact what they wanted to do. Let me tell you another reason why not properly preparing the bear, the legislative outcome, is a problem. This morning, we heard about the case on children with disabilities that were judged this morning. It's a bittersweet moment for me. On the one hand, maybe it provides some level of comfort to families who have a child with autism and an opportunity to maybe put them in a private setting, a residential setting, where they can get the care they need. On the other hand, the bear is not ready to be skinned. Because I know what's going to happen. What's going to happen in all but 9 states that have actually had the courage and dealt with the opposition to come up with a way for a child with autism to have an IEP developed that the public school is not satisfying and have funds go to the private school. We haven't given clarity to those other 50 or 41 states. Parents are still going to have to fight. They're still going to be uncertain. Why? Because we haven't done our jobs. If we're serious about this issue, do our jobs, not force you, because now what's going to happen, I'm not an attorney, but I can pretty much guess what's going to happen in states that haven't had the courage to take this issue on. I had a lot of Democrats vote against the bill. I had probably 50-50. Democrats vote for that bill because there are special interests that don't like opportunity scholarships or don't like public funds going to private schools for other reasons, because they think other students will get access to it, and they're willing to hold these kids hostage when they know they need this help. Now, in North Carolina, we have about 1,200 kids with disabilities because we skinned the bear. We hunted the bear. You didn't have to deal with it because we took affirmative action in the state legislature to do it right. Now what we're going to do is determine the consequences of this action of the court taking the position they did that's in conflict with how you all ruled in Luke P. They're not going to know whether or not they can take the kid in. They're going to have to spend a lot of money probably fighting with the school system to ultimately get that child into the proper setting to be educated. They're still going to have uncertainty. They may have certainty about the legal view of this particular case, but they have no certainty about how they're going to help this child, how they're going to get them the education they need, how they're going to be able to generalize the skills they may learn in the classroom, but like in the case of Luke P., not have it transcend into the home setting. So we haven't done anything good as a result of causing you all to do our job. In fact, you don't do our job well. Legislators are bad judges, and judges are bad legislators, just as you said. So we still have to fix that problem. And I don't think that it's a problem at all for you to say that we have an overweening addiction, liberals and conservatives, to constitutional litigation. Why do they do that? Because we're not doing our job. Because we're going off into our individual conferences and not coming to a consensus on something like education for children with autism. That's not a hard problem. It's one I solved. It's one my colleagues and I solved when I was Speaker of the House in North Carolina. So much of what we're talking about today, the 5 cases out of all the cases that you've been involved in are almost all rooted in the reality that we haven't done our jobs. And we're just going, well, you know what, we'll let the judges work it out. I don't want you to work it out, because you can't possibly work it out to the level of specificity that is required to give the little guy, that child that needs education, those parents who are living paycheck to paycheck, the certainty that they need to take care of these very, very difficult challenges. So we need to do our jobs. There's virtually no case that was brought up today that people took exception to your position, even when you were in the majority and writing the concurring opinion, that isn't rooted in a lack of definitive action, bipartisan action, problem-solving action by this legislative body. And I, for one, think people should go back to these cases. I don't care if it's, if it's on, gosh, every one of them. I'm not even going to go through them all. Trans Am Trucking, Thompson versus Luke P., all of them, where they're talking about they didn't like your outcome. They didn't like the legislative fix. It should have never required you to fix it, required us to fix it. And Riddle, this is something that I just remembered this morning, or as Senator Hirono was speaking about politics. I don't, do you have any earthly idea what was it, Republicans or Democrats that passed along in Colorado that was the subject of Riddle versus Hickenlooper?
I don't know.
You have no idea. But here's the thing I said last night. I don't think Senator Hirono was here when I said it. You managed to make a lot of people mad there. You exceeded your 50% threshold because you made Democrats and Republicans mad because it benefited them. To some little guy, small party, startup sort of party effort in Colorado. I think the numbers defy the narrative that you're for the big guy, just by the sheer volume of cases that you've heard where there's been great consensus over it. So this whole narrative of you being for the big guy, are you not solving problems that we created? You know, I say oftentimes here, we have this tendency in Senate hearings to bring witnesses before us where many of their problems are rooted in decisions that past Congresses have made, and then we beat you till you bleed, and then we beat you for bleeding. And that's exactly what we're doing here. I think that we really need to look at ourselves and put a mirror down there and ask ourselves, really, a lot of the things that we're potentially criticizing you for are your problem? No, they're our problem. We did not properly dispose of the bear before you were required to skin it. So I am going to do a part of the third round, but in the interest of time, Mr. Chair, and I'm going to, asking questions, here's one thing I don't intend to do on this committee. I'm on the waiver here, so I'll always be at the tail end of the committee. No matter how senior I get in the Senate, I'll still be here as long as I yield back at least 4 or 5 minutes, and the chair supports me coming back on the committee. I don't ask questions that have already been asked that have been answered satisfactorily. And I think you've done a good job of answering a lot of questions over the last 3 days. And I look forward to what I hope is the final round. And I look forward to supporting your nomination. Last thing, you know what, I'll hold off until that. But there's one thing that I think we do have to talk about in the third round, and that has to do with the disturbing trend that I see here of increased polarization. But I'll wait and talk about that in the final round. And I yield back my 9 minutes and 1 second of time.
Thank you very much. Senator Kennedy.
And I'm going to go watch Jeremiah Johnson.
You got it.
Thank you, Mr. Chairman. I want to kind of choose my words carefully here. I've listened really carefully, and I think I've been here as much as anybody else has, if not more. But I still have some questions. I think from my questions and from my comments, I've demonstrated pretty clearly I'm very impressed with you, Your Honor, and I think you'd make a great Supreme Court justice. Some have criticized my friends on the other side for asking you how you would rule in specific cases. And I don't think that's an appropriate question. But if I'm going to be honest, I would have to say I'd love to know the answer to that too. Because we live in a real world. And I can tell you my people, in selecting a president, who he was going to appoint to the United States Supreme Court was one of the main reasons that some of them voted for him. And I can assure you that if you're confirmed, and I think you will be, and you go on the Supreme Court, and I don't think this will happen, but it's happened before, and you act in a way unlike one could reasonably conclude you would act as if, based on what you've said here. I don't know how to put it. If you went on the court and started acting like Andy Kaufman or something, my clients are going to, my constituents are going to have something to say about it. So I don't want the fact that I'm still asking you the questions to be misunderstood, but this is a big deal. I'd like you to walk me through one more time how you would approach construing a statute. Let's suppose a state passes a law that says no law shall discriminate against people on the basis of eye color. I doubt that'll ever come to the U.S. Supreme Court. I doubt a legislature will ever pass it. That's in front of you, and you've got to construe it. What's the first thing? What are the steps you go through?
Senator, I understand entirely the desire of everyone to want to know the views that I might subscribe to personally, and get me to make commitments about how I'd rule in future cases. I understand it.
I'm not asking you to do that, Your Honor. I hope you'll understand that.
I do, but I'm not saying there's any improper questions. There are only improper answers. And as a judge, as a sitting judge, I am bound by canons of ethics.
Right.
And I've tried to be as full and as open as I can possibly be, consistent with those canons. And those canons are important. They're important to me because if I did make a bunch of campaign promises here, what's that mean to the independent judiciary? What does that mean to the litigants in front of me? What does that mean for the future of this country? Those things are important to me. And there's a long line of judges who've come before me. And this is an unbroken chain.
Mm-hmm.
And I don't want to be the weak link.
I understand.
That's important to me. In terms of statutory interpretation, you start with the text of a statute. You look at its plain words. You consider how a reasonable person would understand those words, the affected persons at the time. Right? You look at them, they have a fixed meaning. And you try and apply it according to its plain meaning as best as you humanly can.
Plain meaning to whom, Your Honor? To the lawmaker, to the people who have to comply?
To the people who have to comply, to the average person, the public understanding.
Okay.
Not a private understanding. We don't live in Caligula's world. Thank goodness. Right? Caligula, who posted, as I've indicated before, his laws so high in a hand so small nobody could read them. He knew what they were. Mm-hmm. Secret law. Right? Ours is public law. That's our system, made by the people and their representatives, a government by the people, for the people. And a judge's job is not to become a legislator and rewrite it and fix the problems in it.
What if the words are unclear?
Well, if the words
Well, let me stop for a second. I apologize for interrupting, but I'm probably going to be cut off here in a second. Suppose the words are clear. Do you just stop?
You stop. You're done. Well, unless you have a constitutional difficulty. You're talking about a statutory interpretation case, though, so I'm assuming we are just dealing with statutory interpretation. And if the words are clear, you stop.
Wouldn't you want to go take a look at the legislative history just to make sure that you're right, that the words are clear?
Senator, the Supreme Court of the United States precedent is quite plain on this very point. Hmm? If the words are plain, you stop.
In determining whether the words are plain, and look, I'm not about to debate Supreme Court precedent with you. I'll lose handily. But I've read a number of cases that also say it's okay for a judge to take a look not only at the plain meaning of the words, but that legislative history is appropriate. It's not dispositive of what the statute means, but it can be helpful. And it's also okay for a judge to look at a statute and try to imagine what problems the legislative branch was trying to address. And the example I gave last night, admittedly it was late and we were both tired, but I would love, and I'll bet you would too, strike that. I shouldn't have said that. I bet many people would love to have a transcript of the Constitutional Convention that drafted our Constitution. Now, if a member of that convention made certain comments and they were written down and we had a transcript, you couldn't go to his comments and say, well, he must speak for the whole convention. That wouldn't be right. That's a failing of legislative history. But you sure, if Benjamin Franklin said it, you'd want to know it. And that's the case where the legislative history or the problems that the drafters were trying to address could have an impact. Do you think if a statute's clear, you should never look at that? That's honestly a question, not a suggestion.
And I take it that way, Senator, and I'm answering it not from my personal preference, but from a matter of precedent.
Mm-hmm.
And the Supreme Court of the United States, precedent on this is plain, happily. This one I can give you. If the statute's clear, that's the end of the interpretive exercise for a court, period. Period. You're correct that if there's an ambiguity in the statute, then a court will look to other tools, canons of construction, perhaps the legislative history. There's a debate over how valuable that is that we've all discussed several times in the last few days, and the value and some of the issues associated with that. I respect very much the work of this body. When I'm a judge, I like to get every scrap of information anybody wants to put in front of me. I read it all. I take it all seriously. There are problems we've discussed with perhaps too much reliance on legislative history, the due process issue, right, that we've discussed, the Caligula problem, the fair notice problem, the bicameralism and presentment issues we've discussed in separation of powers. It's not the law, but you look at everything somebody gives you. A judge doesn't say, I'm not going to read that brief today because I don't like the color of the brief. You know, it should be a lighter shade of blue. You know, I look at all material put before me. But when the statute's plain, Senator, the President of the United States says to the judge, stop.
Okay. And when it's not plain, which I think is oftentimes the case, well, many times the case, we can probably agree on that. If Senator Tillis or Senator Coons or Senator Franklin passed a bill and it's not clear, then would it ever be appropriate for a judge to say, okay, it's unclear, I'm going to take a look at legislative history, but I'm also going to try to, through looking at the legislative history, try to understand what was the problem they were trying to solve? Is that ever appropriate?
Senator, I'm not sure what you mean by that, to be honest with you.
Well, why did they pass the statute? Would you ask yourself, why did they pass the statute?
Well, one concern I have with that enterprise is I have a very difficult time getting in the head of anyone else.
Mm-hmm.
And trying to get in the head of 535 of you, plus a president. Well, frankly, Senator, that's often beyond me.
Okay. Let me switch to another subject. The Third Amendment. I don't remember the language. It's quartering troops. It hasn't gotten a lot of attention, and there hasn't been a lot of jurisprudence on it. But some think that it has privacy implications. Have you given any thought to that?
Senator, I think it does suggest, hey, my house, is off limits to your troops. There's a privacy implication in there. Yes, I do.
Okay.
Yeah. Yeah.
I think Justice Douglas cited it in, it was either Griswold or one of the privacy kind of cases. All right, let me ask you this. I want to talk to you a second about state action. I don't need to tell you, you know better than I do, the Bill of Rights protects us against government. Some state constitutions have bills of rights that actually establish our rights vis-a-vis each other as individuals, but the federal Bill of Rights doesn't do that. It's our protection against government. What's your feeling about the state action requirement? What do you understand a state actor to be?
Senator, you're going to have to help me out. In what context are we talking about here? State action requirement is, the protections of the Bill of Rights are as against the state.
Right.
Against the government.
Right.
Yeah.
Right.
Yes, if that's what you were getting at, yes.
Yes.
Yeah. They're
If-
rights as against the government.
Yes.
They're protections as against the government.
Okay, but sometimes there are entities that are alleged to be acting in the shoes of the state, agents of the state.
Yes. Yes. That's an interesting problem, right? Because Congress today has created a multiplicity of arrangements. And is it government or isn't it government? It's actually a question that arises from time to time. And if you'd like a look at what I've written in the area, I might refer you to U.S. versus Ackerman, another case where I ruled for the little guy, maybe, if you like. And it had to do with whether the National Center for Missing and Exploited Children is a governmental entity. And the line of cases in the Supreme Court goes all the way back, the Dartmouth College case. And it's a fun read in terms of the Dartmouth College case. What qualifies as a governmental entity? The Supreme Court of the United States recently struggled with the issue in the context of Amtrak. So there are questions around this area as to what is government and what isn't. Very important, because if something qualifies as government, it has to square its corners under the Constitution and the Bill of Rights, of course. So, for example, in the Ackerman case, if NCMEC's a governmental entity, it needs to comply with the Fourth Amendment. Can't invade personal privacy without complying with the warrant requirement, for example. Yeah. So they're very important questions as to what is and what is not a state actor.
Yeah. Well, I want to be clear for the record. You mentioned the little guy, and I know that's come up a lot, and everybody's entitled to their own opinion. I was taught justice is blind, and it doesn't matter whether the party is, it doesn't matter its wealth or its status or its power. You decide cases on the basis of the law. I mean, Lady Justice is wearing a blindfold. So I agree with you completely on that. I understand the other point of view, but I don't agree with it. Your book on euthanasia. Could you, kind of like you're talking to a 10th grader, give me a summary of your thesis in your book?
I can try, Senator. I find it a very hard issue. It's one every American has deep, understandable views about. It concerns the end of life.
You can pull the mic just a little bit closer.
I'm sorry. Of course, I apologize. The end of life, which we all face.
Yeah.
It's a problem all of us face. And it's a book in which I struggle with the end of life issues that we all face, and how we as a people might consider resolving them. Wrote it before I became a judge, as a commentator, with my thoughts as an individual, not as a judge.
Well, what I read of it, as I told you last night, I didn't read the whole thing, but I read parts of it. It's very well written, and it is something that we all have to deal with and we all think about.
Yeah, and I don't, I appreciate you having read some of it. I suspect until about a month or two ago, it hadn't been exactly widely read.
I have a feeling it is now, Your Honor.
Well, I expect it'll make a good door jam for most folks. But I conclude that there is a very important interest in being left alone in life, and that there's an understandable and appropriate zone of privacy there that we need to respect. And we've all experienced it when a parent or grandparent wants to go home. Had enough. It's time.
And your thesis, once again, not to replow old ground, but want to be sure I understand, is not based on religion.
Goodness knows.
It's
Senator.
secular, it's based on your secular moral values.
Well, it's not even my, it's an attempt to work
I don't mean to
through-
imply they're yours. It's based on, not your thesis is based on secular moral values.
Yes.
That once you cheapen life, once we become desensitized to taking life, it's easier to take the life of those who are less powerful than you and I.
Senator, that's one worry I expressed, and that the difference between refusing treatment and killing people raises with it questions about what happens to the least amongst us, the vulnerable, the elderly, the disabled. And I don't profess to have the final answer here. I'm not a philosopher king. But I do know that when you have a more expensive option and a cheaper option, those who can't afford the more expensive option tend to get thrust into the cheaper option.
Yeah.
And so those are some of the concerns I worked through. It's a long book, it's complicated, and I do not profess to have the right, final, or complete answer. I hoped at most to contribute to a discussion on an unanswered social question where all people, and I do think all people, have a good faith interest in trying to reach some consensus socially on it.
Well, it was well written. What I read, it was very well written. Got you an Oxford D.Phil. It was your thesis, wasn't it?
More or less.
Yeah. Well, it got you an Oxford D.Phil. That's pretty good. How am I doing, Mr. Chairman? Okay. I'm going to yield back my time. Thank you, Your Honor.
Thank you,
I appreciate
Senator.
it very much.
I appreciate it.
It's on our iPhones that the vote is starting right now, so we will recess now, and we'll reconvene in 2:26 for probably, I would guess, a half hour, depending on how long the discussion goes on. And then we'll come back here, and we'll start with the third round. And I hope not everybody takes the third round, and I hope everybody will try to stay in less than 15 minutes. Thank you very much. Judge, the time is yours for a while.
Getting near the end of day number 3 of the hearings for Neil Gorsuch. They will resume after the Senate Judiciary Committee has its closed session, going underway in just a little bit.